you can see, and the collaborations and the information sharing. Now, when we are talking about a pre-litigation risk analysis, companies they have to conduct a pre-litigation risk assessments to evaluate the strength and the weakness of their IP position. Because if I say that yes, infringement has happened, my patent is like a copied by say X company, right. If I say that, I have to be very careful to enter into that particular dispute, I have to do the claim analysis, I have to just check whether, because first attack will be in invalidation. So, whether we have to check whether my patent is like having a taken that strong, my claim drafting is very strong, and that is very important. And therefore, when you draft a claim, you have to think in that direction only, that whether if any litigation comes, whether this draft will survive to that particular litigation, that or this particular invention is of that particular level, we have to consider, we have to take care about that, right. So, this infringement claim, then identification of opportunities for resolution, all analysis you have to do, and then only you can enter into that.